Whew. All right, everybody. Let me make sure the camera's all right. As you can see, Nate Brody's lamp is making his appearance again. I even put like headphones on him, uh, so we are making it happen tonight. All right, how's everybody out there doing? Let me see how the chat is working out. It's on slow mo tonight, so you guys ain't got to worry about typing the fire away because now you guys get some time to read it all up. Please, mods, let me know if anything's going on interesting in the chat. My name is Nate Broady, lawyer, YouTuber. Can everybody hear me all right? I hope everybody can hear me all right. There it is, Nate Brody's lamp. Appearance in the back. I'm gonna hook you up. All right, so you guys aren't here to see me play with my hair and talk about Nate Brody's lamp. You here again to see what Kyle is going to be putting out. So everybody knows what's going on. Kyle has sent me what looks like his evidence for his motion to dismiss. So he's given me the documents to show that he didn't live at the place where he lives. So I have the court documents. I believe he's going to file it tonight or tomorrow. I'm not even sure, but these documents, so he sent it to me. Again, I'm not sure if he's going to file these exact same documents. He's told me he's going to file these documents, but you know, until they're filed, who really knows? Let me see. I got to put some ear. Yeah. Nate Lamp for president. So what are we going to do today? All right. So today, let's go over and let's look at Kyle's submission and see what evidence he's providing. Now, for all of you who've been living under a rock for this case, let me just start from the beginning. The Non Sequitur Shows, a case was a show here on YouTube, and it had two hosts, Kyle Curtis and Steve McRae, and they had a falling out. Kyle essentially kicked Steve off the show. They were supposed to be 50-50 partners. Then when all went to hell, Steve eventually sued Kyle in North Carolina court. So Steve essentially sent the complaint and summons to Kyle's former address, his old address, his family home. But Kyle had moved, supposedly. Now, Steve knew that Kyle had moved and knew that, but couldn't find his new address. So that's where we're at now. Now, Steve's argument is that Kyle was served properly, even though it was an old address. And Steven, I think his crew has even made the sense. Hold on, I gotta guess. Dragnot. What's up, Drag? What's going on, baby?
Okay, what's going on? Let me make sure. Yeah, let me make sure I got my stuff coming through here right. Okay, there we go. We should be good.
Through. I can hear you.
All right,
I can hear you.
I gotta make sure.
All right. Nate Brody's lamp is like getting. I gotta make a channel for the lamp. It's going to have like 100 million subscribers. The lamp is like is the bomb right now.
Lamp is a slayer. You got Nate Brody's lamp. I got Drag Goatee, and Drag Goatee is fucking savage. Like, oil me, bitch, oil me. Like, just begging people for donation to oil. I'm like, somebody got jokes. But it's funny as hell.
My God.
It's funny as shit.
Oh, it's it. Yo, so I'm just going over the history of the non-sec beef. So how did we get here? Kyle didn't show up to the lawsuit. Default judgment. Now, for anyone who doesn't believe that I'm an attorney, because I'm not an attorney, right? I'm not an attorney, as the other side is saying. Nate Broady is not an attorney. Whatever.
Is that the hold on narrative? Is that the new narrative now?
Yeah, that I'm not an attorney. $2 from Busy Pack Rate. Nate Brody's lamp is the fever.
A flurfer. That's flatter.
Flurfer. Sorry. But so the narrative is now that I'm not an attorney. You know, it's, you know, I've got they need my full. And the funny thing is, let's not forget, Steve also has my real name. He also knows I'm an attorney. Reds actually saw my ID from the damn DA's office when we met up, so they obviously know I'm an actual attorney. It's you know, but again, they got to kind of discredit anything I'm saying by any means necessary. You know what I mean? So any of this information I'm giving, pretend that I'm not an attorney. Matter of fact, I think I would. It would be best if you did, you know, just look at the information I'm giving you. Don't consider I'm an attorney. Now, another big issue is, you know, how come Kyle is giving me the information? I'll just speak to that real quick. Do you guys remember the Matt Dillahunty case, the Matt Dillahunty versus David Silverman, and when David Silverman was suing? I got some documents that no one else had from that case, also that case too. And the reason why I got those documents is because I did something kind of crazy. I went and asked the other side for their side of the story, because no one had actually went to American Atheist. No one actually went to that side and said, well, what's your side of the story? David Silverman was going out here doing his, his speeches, and no one else actually went and just said, hey, what do you guys think about this? I did
crazy
that.
shit. Crazy.
Yeah.
You actually went. So this is an unprecedented thing that you're doing here, where you hear something and then you go to all parties involved and you gather information rather than just listening to one dude or his dick suckers. Is that when did this shit start?
Well, it's something that I just always like to do. Hold on, I got 2 super chats. Let me throw these things bad boys out there. Mary Carmen, for your law school tuition. Thank you. I need it because I'm not a lawyer. And love ya. Money for law school. Thank you. You know what? That's money to pay for my $100,000 in law school loans, which is, But thank you so much, She-Wolf. She-Wolf, I love you. Thank you for the super chats. But now, where was I at? Damn, this love has got me crazy. So anyway, my non-lawyer behind all of a sudden. So what happens is that we're at this point in the case where Steve thought he won, and he's telling everybody, and there's an issue that comes up. The issue is, was Kyle served properly? Now, let me just get this misnomer. One of the worst arguments I've been hearing is that Kyle knew about the lawsuit, right? Kyle knew about the lawsuit. I can tell you how many clients that I've had that knew that people were trying to sue them, and they ran their asses and tried to avoid service like a madman. It just happens. People don't want to be served with lawsuits. That's the way the game is played. But it's on the plaintiff to find the defendant.
Can we hold on for a second, man? Because I know you wanted somebody saying I'm hot. Hi, but let's start with service. What when you say someone's you're serving somebody, there's a process serving. What does that actually mean? Like, what's the definition?
Well, just so we can all be clear. Hold on, let me get this $5 super chat from Tadded. Tadded says, toss a coin to your lawyer. Second hand smoke fake. Bill is the best geek. Thanks, Billy. I appreciate it. Yo, thanks, Tad. Again, thanks for the $5 super chat. I appreciate it. So let me draw this back and let's talk about service. What happens is, to initiate a lawsuit, you have to serve the other side with process. You have to give the other side the documents so they know what they're being served, what they're being sued for, and what court to show up at. And that's how you do it. And there's a certain formula, certain ways that you can do that. In most states, you can just, if you go hand it to the person, right? You physically hand them the documents, and that's kind of considered personal service. Or you could take it to their house and give it to a person who's of age. And there are different ways you can do it, but they're very, very strict about how you do that, because just when you serve somebody, that actually starts your lawsuit. You filling out the papers does something, but actually giving the person the papers, acknowledging that they got it, starts your lawsuit. Because what happens is, when they get the papers, they now have a statutory amount of time to respond to that lawsuit. And so if they don't respond, then you get a default judgment. So that's why it's very, very important to serve the person properly. That's what we're talking about. Did that answer your question, Drag?
Yeah. Okay. So, because I know what this is, but over 200 some people watching, so not everybody might not be on the same page.
True. That's true.
So that's what we're talking about. You can't just shoot an email to somebody and just say, well, you knew, I told you while we were arguing over lunch that I was going to sue you. I shot you an email with like a draft of it, so you knew it was coming. It's my understanding that and so it's my understanding that there's an actual person, like there's a job attached to this whole thing.
Yeah,
so you pay that person to do that action that you just described.
Yes. Now, for instance, when usually if I have a client, we usually go through personal service. So you can usually pay someone. It ranges from $50 to maybe $200, where you actually pay somebody to actually go and serve the person. They go to their house. They go to their, because what happens is you don't want to make this mistake, because if you make this mistake, then it can destroy your lawsuit. You win your lawsuit. The next the person says, I never got the lawsuit. It could be a big problem. So that's why it's very, very important to just spend a little extra money and serve the person properly, because you just don't want that mistake coming back to bite you in the ass. $2 super chat from Tatted. Steve doesn't care about statutory ass warden. That's true.
Oh,
That's true.
low blow. Well, when you say this could destroy your case, right? Like, what is that? Everything can get thrown out. Is there like a precedent for that? Is that's not just something you just saying?
No, what happens is, and this is, if you guys don't believe I'm a lawyer, what you can do is you can go to YouTube and Google how to set aside a default judgment. You'll see lawyers from Alabama, North Carolina, whatever state you want to see it from, and they'll explain to you what happens. Generally, if you don't serve the person properly and you get a default judgment, everything kind of unravels again. Everything goes back to it, and you go back to the beginning of the lawsuit, and each party then has, either the defendant has a chance to answer and talk about the lawsuit, or sometimes the lawsuit can just be dismissed if some malfeasance was had. So it really, really, really depends. But generally, if you don't serve the person properly and you get a default judgment, that default judgment becomes void, null and void, and you start at the beginning. So that's kind of the way the process works in all states. But again, it's the specifics get different as you go from state to state. Let me read this $5 super chat from Gabriel. I had to hire a lawyer for my son against the school. I learned quickly what I think, and the points I had were very different than how the law works. That is so true. Thank you, Gabriel, for the super chat. It is very, very different.
Course. That's a system shocker right there.
$3.99 for Mary Karen. Know about a job. You're all crazy. Yes, we are. Thanks again for the super chat. Now, mind you, one of the fundamental pieces of process service is that the plaintiff has to find the defendant, right? The plaintiff has to find the defendant. I gotta find you. If I'm going to sue you, I gotta go to where you're at. Like, that's why Steve had to go to North Carolina. He had to go to find Kyle to sue him. He couldn't sue him in California because Kyle's never been in California. You got to go to where the defendant's at, and you have to file process against the defendant there. And that's why we have private investigators and process service. This is what they're paid to do, so you don't have these type of mistakes. And if you mail it to the person, but you mail it to the wrong address, sometimes that could be wrong. Now, I want to preface this by saying I am not an expert in North Carolina law. I've never practiced there. To be honest with you, I'm even scared of looking at the laws at a different state. But the general rule is that if you're going to effectuate service, there are very specific ways you can do it, and you have to serve the person at their residence. You can't serve the person at some other residence. You got to serve them where they're at, because the most important point is that the person knows that they're being sued and can respond. That's what we're looking at. Any questions, Drag?
No, it seems pretty straightforward. You just can't send to last known address and hope it gets there. You have to actually have somebody verify that it is in the hand of the person that you are trying to sue, not a relative, not a boyfriend, not a girlfriend, and it's dictated by the case law of that state.
Yeah, and the statute, because I know, like here in New York, for instance, I have to send it to your house, but if you live with your wife and your wife happens to be over age, I can deliver it to her. And then, but she is then responsible because you both live there, and live there in the same place. That's different than if I'm sending it to your old address where you don't live there anymore. And that's generally here that it would be done. It's funny because I was speaking to another attorney just before the stream, and I asked him. I was like, "Hey, listen, in your state, is it like that?" And he laughed at me. He's like, "I don't know any place that would allow that. That sounds crazy. Where they'd allow you to serve somebody's past address 20 years ago. That's stupid." But again, that's the narrative that's being put out here, that you can serve someone. Let's say if I lived in California 30 years ago and that was my last known address, they can serve me in California. That's stupidity.
Right.
So again, that's what we're trying to
There's
suss out
a
here.
distinction between last known address and legal address, like Joey D saying in the chat. Those are two separate things.
Yes,
Okay.
yes. Two separate, and it's on the plaintiff. It's the plaintiff's responsibility to find the defendant. It is not on the defendant to go look for lawsuits that they may be filed. That's ridiculous. And one of the other narratives that are being put out there is that you have to register your address. Where the hell, like, who in the chat has ever registered their address with the courts?
What do you mean register and
That was some argument that was being made that you got to register your address at some courtroom or something like who goes and registers their address at the court?
What?
You know what I'm saying?
Please don't tell me 62 IQ said that.
I don't know. I think 62. I think somebody said some idiocy like that. I was like, I've never registered my address anywhere.
Like I register at like the university, right? My address or like my utility place, or like I'm not sure what register with. If I'm not going to a court, why would I need to register myself with say court? I don't that maybe there's some context that we're missing, but it seems like post hoc to my super chat didn't put anything. But yeah, it just seems like something, or excuse me, ad hoc that they just add on there. You had to do that, just like every piece of everything needed to be notarized, evidently.
Yeah, there are certain formalities. Let me read out Hannah Anderson. Hannah, thank you so much for the $10 super chat. The bottom line is the judge will determine how this will end, and that's of course that's the way it's going to be. And the only thing we're doing is reading the tea leaves and looking at what's happening and doing commentary on it. This is it's just the way it is. 199 from Lisa Ann. Thank you, Lisa Ann. Laugh Ann.
Lisa Ann is somebody different.
Yeah, I'm thinking about Lisa Ann Presley, but that's Leif Ann. I hope I'm saying it right. Leif Ann. Thank you for the super chat. Thank you for the dollar.
Lisa Ann, but okay.
It's a beautiful picture too. All right, so I just want to make sure everybody understands this. Now, it's a weird little instance here because right now, I just want to make sure we're clear what both sides are saying. Steve is saying clearly that Kyle was served properly. He was served at his prior address, and he knew for a fact that it was his prior address, and he knew for a fact that he moved. So he said, yes, he moved. I know that for a fact. I know that was his old address for a fact, and I know that he did not sign for it. It was someone else. So those are the facts, undisputed. And I think that hopefully colors how we're going to think about this moving forward. All right. So you ready to look at some documents now, Drag?
Let's do it. Might as well.
All right. Here we go. Here we go. Let me know if these super chats, because I gotta switch screens to go to the motion. But here is the motion. Here is what Kyle stated. Now, this is, to be honest with you, it's not in the right format, it looks like, but it is what it is. And he puts here motion to set aside the case with prejudice and stay. Yeah, that now this with prejudice means he's asking the court to end it and not allow Steve to bring it even back up. That's what with prejudice means. And stay all proceedings until this motion is addressed. So he's asking for something huge. I think that's highly unlikely that they're going to dismiss it with prejudice, but it really depends on what could have happened. He's sending it to Steve's lawyer, and here it is. So let's start at the beginning. Dear sir, I request to motion the court to set aside case with prejudice and stay on all proceedings until the motion is addressed. So the stay on all proceedings, in other words, he's saying you've got to, more or less, you got to order out there. I want you to stop everything and address this motion, because if he didn't serve me correctly, then we got to give you back everything anyway. So just this needs to be addressed before we move on. He says, I asked the court to have the above referenced case and default judgment immediately set aside with prejudice and a stay on all proceedings until the motion is addressed. So the wording here is a little poor. I'm thinking he's asking for the stay, and then after whatever they do down there in North Carolina, they can ask for the case to be dismissed with prejudice. So he's going for the jugular. Kyle is going and saying this case
cut it off at the knees. Like he's like, all this needs, even though the default judgment was already rancid in favor of Steve. He's like, you know what? All that needs to stop. Nothing going nowhere. Don't pass go. Don't collect $200. I wasn't served properly, so you need to dismiss this, but not just dismiss it. We don't need it. It can't be resurrected after that.
Yeah, but now you got to have a good excuse why that is. Let me throw these super chats real quick. All right, we got $5 from David Street. Hi, Nate. Thanks for providing your legal insight. Will YouTube wait on handing over the channel to Steve until Kyle's new filings are sorted out? That's what we're going over now. So hope it seems like there may be this hold until we figure it out. Because if he wasn't served properly, then all the stuff that has happened so far is going to be reverted back to the beginning. So that's what we're looking for. And I'll actually play a clip of another lawyer talking about it, because for some reason, if I say it, it's like, it's no good. But if another lawyer says it, then it's like, all right, then it's all right.
Man, YouTube lawyers, man.
This is from Twitch Chicklokin. $10 super chat. Thank you. The School of Nuke. That's true. The School of Nuke. Thanks for the $10 super chat. And we got $4.99 from Princess Jamet. If you sue someone, you have the responsibility to find them. Correct. And their residence. You got served. Amen to that. Amen to that. Hey, and I love you. I love the channel. I'm a subscriber too. I see you out there. Thanks, Princess Jamet. Thanks for the super chat. $5. All right, and I got another one coming up. No. All right, so let's get back to the documents, people. So Kyle is now asking for this to be done with, over. Don't let Kyle even bring it, but he's got to have some good reasons for that. You can't just say that. You got to have good reasons for that. Let's see what he says. The law requires that the summons and complaint be delivered to my primary address or dwelling, if using certified mail. Now, he doesn't have a citation here, but that seems to be the rule in North Carolina. From the case law that I've seen, it has to go to your address. It can't, I can't serve your mother's address, your father's address, your brother's address. I'm serving you. I got to send it to your address. But again, it would be good if he had a citation of law here, but he doesn't.
Okay, so he's referencing law, but he needs like a citation, whatever that fucking squiggly symbol is, and then 185.A7 subsection D states here that yada yada yada. So would be the proper way to do that.
Yeah, what you'd want to do is to cite the controlling law that because he's saying the law is this. It says you must do this, and without that citation of it, the court is not, well, as an attorney, I would have to cite it so the court knows that I'm just not pulling this shit out of my ass. But here, I think, because especially since he's pro se, the court's going to give him a little bit more leeway and say, okay, we know what you're talking about. If the law is good, they'll say, okay, the law is good. You don't need the cite because we know the citations. And I'm assuming if this is business court, they know these citations by heart. You know what I'm saying? This is a simple service issue. So let me get back to the document. So Kyle hasn't cited anything, but I think this is understood that you have to send it to the person's actual address. The plaintiff knowingly used an old address to improperly serve me the complaint and summons. The plaintiff admits to using my old address in an effort to use the court system to his own ends. As evidence of this wrongdoing by the plaintiff, I have enclosed the plaintiff's admissions on video. The plaintiff says he knew I moved and sent the paperwork to the wrong address on purpose. The plaintiff says this on his YouTube channel to thousands of people, making a mockery of our legal system. I have provided the recordings to the court and links to the plaintiff's videos and admissions here. He even puts the link.
So Kyle said,
I will. Yeah, go ahead. But listen, look at this shit. I will be calling the plaintiff himself as a witness in the evidentiary hearing. Boom.
He said, making a mockery.
Making a mockery out of the legal system.
All right.
Oh, okay. This California guy's coming to North Carolina, making a mockery. I got a $2.99 super chat. Let me say, who knows when he actually got it from mom? That's true. Hey, Layfan, thank you. That's you're 100% right. Who knows when he actually got it? Because don't forget, there's a time frame about him responding to this. So so Kyle seems to be going for the jugular, and he's saying that he wants to call the plaintiff himself as a witness to the fact that he wasn't served at his home. So
is a YouTube video though? Like, is this something that we see in law? Because, like I said, I feel like you feel when we're talking about science. I have no fucking idea, but is a YouTube link is what a judge can review and go, oh yeah, I see what he's saying here. Yeah.
Well, again, I don't know. I don't, because in every state the maybe rules of evidence may be a little different, but here it's all about authentication. Can you prove that video? You know, what date was it produced on? Who produced it? You know, you got to have the person say, yes, I recorded that video. And if it's the plaintiff, then it's the plaintiff. You know what I mean? So there may be some steps in there to actually authenticate it, but you know, barring that, yeah, you can definitely use it. It's on video. You know what I'm saying? It'll be hard pressed not to pull a video. And especially one thing I do like about this piece about calling the plaintiff is that now you're asking Steve to get his ass from California to come to North Carolina to testify in the North Carolina court. So that may be a little crazy. You know what I'm saying? Yeah, because now if you want to testify, you can't testify sitting at his ass, and you got to come to North Carolina. You know,
tell us. I don't know what county they're in, but you know that's all I got to say. Okay, so that's interesting. So he's gonna force Steve's hand on that. That's all right.
Yeah, bring your ass from California. No more suing from across the country. You got to come talk to us.
So it's a two-pronged issue. I'm kind of seeing. So there's an issue where he's saying that Steve said like overtly that he sent it to the wrong address, which probably not going to look good in front of a judge, because why are you wasting our fucking time doing that? And second, it's improper service. So, you know, that, and I think that's the more pressing issue.
Yes. You're right. It's a layered argument. First, it's improper service. And the second one, he's saying it's intentional improper service. And the plaintiff himself has made these admissions. The Operation Shareke Freedom. May Raptor Jesus watch over this case. Amen to that. Thank you for the super chat. Awesome, brother. Maybe it'll work out. Did I miss one? I think from C. Darwin, I missed a $5 from C. Darwin. Let's get serious now and talk about the important cases. When are you going to go over Kent Hovind's court case? Let me see. Your first review was great. Thank you. I did go over, but you know, Kent Hovind, he's it's a whole different ball of wax. But let's get back to this case, because I think this case is still fascinating. He's got so many twists and turns. It's unbelievable. All right. So Kyle has now said, I got evidence, and my main evidence is the plaintiff himself. He says that I was not served at my house. It was an old address. He knows that. That's my best evidence. But also, you know, I want to call him as a witness because he's the best witness. He knows for a fact he served the wrong address. I think it's powerful stuff. So last paragraph. At this time, there is no controversy about whether the service was improper. The plaintiff admits that it was not on video. Like he got it all caps, all video, on video. The plaintiff's admissions and the evidence provided make it clear that this judgment should be set aside in the interest of justice. All right. The plaintiff has lied to the court and served the wrong address to deprive me of my day in court.
That needs to be substantiated. That's a leap. Come on now. Okay, you know, it's a dishonor to the court, wasting people's time. Okay, yeah, I'm kind of there, but you really pushing it with that. Like you really, because he could have thrown in some other monkey wrenches if he was really trying to deprive you your day in court, right? I think that's pushed a little bit too far.
This is litigation, though. In litigation, this is what you do, though. You throw crazy shit at the wall, and you hope it all sticks. You know,
man, this is fascinating. It's like he chopped me off at the knee. He's hit me. I used to be an adventurer until I took an arrow to the knee. He stole my sweet roll, just everything.
Can't release one for $5. Who is going to volunteer to ride with Steve on the Greyhound bus to North Carolina? Who knows? But
an escort, somebody hold his hand.
But that's if the judge, you know, makes it happen. So that's crazy. So let's continue on. So yeah, so Kyle is obviously being a little crazy with this, and at the end he says that I asked that this court case be dismissed with prejudice to warn others who want to deceive the court system and violate others' rights. So he's making this altruistic plea to the court. This should be a warning to others not to try to deceive the court. So that's what we're looking at here. Okay. So now we get to look down to see enclosed evidence. Let's see. A lease agreement, bank statements, tax forms, video of plaintiff stating he was aware of improper service and fraudulent serving, affidavits for witnesses, his mom, and his landlord. And he puts, I attest that this is a true statement and that the plaintiff's lawyer has been correctly served this motion. Respectfully, Kyle Curtis. Boom. That's page 1 and 2. So let me look back to the chat. So how do we feel about the opening kind of little, saute here? Kyle, he coming out the gates hard. He's coming. There's no law there though. There's no law, no citations, but he's coming out the gate very hard. What do you think?
Yeah, it's I see where he's going with it, right? And I'm going to kind of pretend like I don't see where it's going, but it's clear that there's an issue with improper service. Like that's like an almost undeniable fact that it seems as though there is case law, there's precedent in North Carolina about how bold move, Cotton. We'll see how it works. We need to discern whether or not the other bullshit, whether or not the case will be dismissed with prejudice, but how is the court going to handle the improper service? Because there are things we don't know. We don't know the time it took for his mother to sign for it and for him to get it, right? Yeah. So that's an issue. And the fact that his mother got it before him is an issue. That's an almost inarguable point. So this is something that I think a lot of people are struggling with because it's, well, I don't like Kyle. Kyle knew about it. So it doesn't matter how much time he lapsed between when the mother got it. The personal feelings aren't the issue here. The issue is law. The issue is the precedent that has already been set within a statute within North Carolina law. And that's something I think a lot of people are having a hard time understanding.
And the one thing I don't understand, and one thing I just don't recognize is that I tweeted it out, and even on my last stream, it says right there, it says, even if the person had actual knowledge that there was a court case going on, that does not overcome poor service, improper service. So even if the person knows actual knowledge that the case is happening, that doesn't overcome improper service, because improper service, that's it. And that's what they're harping on. So, but again, there may be some procedural issue here we're missing. There may be something that we just don't see. But right now, just based on everything, it looks like, Kyle's argument isn't as crazy as I think the other side's trying to make it seem. It seems to be a valid argument, but there may be something that we're missing. So again, I just want to let everyone know, as of this time, just to be fair, as of this time, before we continue to read the document, Steve is officially winning. What do I mean by that? The presumption of the court, from everything that we've been reading, is saying that Kyle is presumed to have been served correctly, and Kyle has to overcome that presumption. So Steve right now is in the driver's seat. I served them correctly, and the court presumes that I've served them correctly. And Kyle now, so the burden's on Kyle to prove that. So that's where we're at now, and that's why he has to provide this proof, which you're going to look at soon. Let me read these super chats. Without legal service, court has zero jurisdictions equal no content. That's right, Raphael Black. That's generally the way it works. It's called personal jurisdiction. You said it beautifully. Left and how many documents were sent? Did he get them all? Well, we're gonna check it out right now. So we're gonna go right through the documents since you guys want that. All right. So this seems to be the thing that he filed before. Now I gotta say it. This document, there's issues here with this. Number one, this date. It says he was never served the summons to complain in the above entitled case. The court documents state that the summons was sent to this address on November 20th, 2019. That's wrong. I checked it before the stream. The documents were on August 30th, like the last day of August 2019. So this is wrong. I don't know how this is going to affect this, but that date that he has up there is a wrong date. Also, it says that the address above is not my residence since July 15th, 2019. So this may be the saving piece of it. The fact that if this date, July 15th, is before the date he was actually served, which was a month later, a month and a half later, then I think you can still have the argument. But that date that he has there is wrong. The summons wasn't given on that date. It was given actually like 2 or 3 months earlier at the end of August. So, Kyle signs it. and again, it's certified. It's notarized. So that again, that's it. So now Kyle then we start with Kyle's evidence transcript of plaintiff's admission to incorrect service. And he's got the link up here and a transcript. All right. So this is supposedly Steve. I don't know if I can say it in the Steve fucking what's it called? The Steve's voice, but here it is. Very well. I said, okay, great. And then I'll show people how to find it. But I did note, and Jimmy saw this, that, you know what? Why am I reading this shit? Why don't I just play the fucking clip? Because I know where this clip is from. Right? That just makes more sense, right, Drag? Play the fucking clip.
Yeah. Go ahead and play it. I'm looking, somebody's saying in the chat that their reference, you see it, I put it in the private chat. NC General Statute Chapter 1A Article 2 says last known address is A-OK. And I'm trying to actually find that reference here.
Yeah, please let me find it, because everything that we've been seeing says it's not okay. But again, you know, I wish I practiced in North Carolina, because I would be a little bit better with this, but I just don't know. Everything that I've been reading says no. But let me pull up this Steve video. That's one thing, is in Twitter, it's so easy to tweet. All right, I found it.
You actually like Twitter? Twitter's stupid.
Yeah, I'm starting to get pissed off with it too, to be honest with you. All right, so let me screen share this tweet. All right, so this is the transcript that he's reading. Twitter. All right, here we go. You guys should be able to hear this. I'm going to play it now.
Very well. And I said, okay, great. Then I'll show people how to find it. But I did note, and Jimmy saw this, that the information on there was old. That was Kyle's old address. People had known that he had moved. He moved in with his boyfriend, which I don't have the address for.
Okay. So that seemingly, that is the transcript that he is alluding to when he puts right here. That's the transcript that we were reading.
Supposedly, Kyle just let folks know that he did correct the date on that.
Oh, okay, that's fine. Here it is. Yes. So let me see. But I did know Jimmy. So this is the same thing he just said. Okay. So we know that's what he's saying. Let me pull this back. Yes. So we know that's what he's saying. He's saying that he absolutely knows for a fact that it wasn't Kyle's address. He knew he moved in with someone else, and he knew he sent it to an old address. So, you know, is that proper service? Everything that I've been seeing is saying no. But again, it really depends on how it's practiced in North Carolina. So as proof that Kyle didn't live at that address, as proof, he puts in his rental agreement, a month-to-month rental agreement, dated July 15th, 2019. It's an agreement between him and Benjamin Potts. It shows the address, shows how much the rent is. This rent is crazy, $600 a month. Yo, I need to move to North Carolina like right now for $600 a month. This is like insane right now.
One bedroom, I'm presuming.
But yeah, what the hell? I'm living in the wrong damn spot. You know, oh, hold on. Let me see if I got any more super chats. Damn, I fucking missed some super chats. All right, hold on. Let me get you guys in here real quick before we go into this. Let me see. Why does Red's rhetoric so frivolly stand with Steve? Well, you know, this is daddy. He calls him daddy at night. So that's why. Thanks for the super chat, though. I really appreciate it. Viva free. All right, tell Dragnot to tilt his camera 10 degrees down. We're seeing the top of the ceiling. All right, Drag. Tilt it down, man. They want to see the chest. Oh, you put the shirt on now.
I put a shirt. Yeah.
Ah, damn. Thank you for the super chat. All right.
I don't have pants on, so I'm making sure,
streaming in the buff, baby. Streaming in the buff.
I usually do. I'm usually naked. Usually.
So there, before you had the shirt on, it was all there right there, you know. So listen,
I was requested to put a shirt on, so I put a shirt on.
Yo, I'm going to say this though. They even giving this guy a 100. Look, the owner will give tenant a rebate discount of $100.
Why?
That's, I don't know. It says right here, payable in advance of the 20th of the calendar month. Owner will give $100 rebate. So, this is crazy. This is, I need to move to North Carolina because I'm paying way too much for rent. So, but they, I'm like all crazed with the details of this stupid thing because it was like, Graham, $600 a month is like insane. But so he gets all this. Kyle now, this tenant agrees. So this is just like a standard rental agreement. And here at the bottom, Benjamin Potts, there's his landlord, there's his signature, 7/15. So the first piece of evidence, we have a rent agreement between him and his landlord saying you start the rental 7/15 at this place. So that's the first piece of evidence that Kyle has. What do you think? Good enough?
Yeah, I mean it shows, and it's signed by the man who owns the property. So,
all right. Well, we're halfway there. Let me see. I'm late, but thanks for the $5 super chat from Navy Text 37. I'm late, but it is going to cause Kyle issues that he didn't attach any evidence to refute being served in his request. That's what this is. This is the evidence. We're looking at the evidence right now, Navy. Thank you so much for the super chat too. But we're looking at the evidence. This is the evidence that's being attached. This is the one that he's turning in. So first is the rental agreement. So I think the rental agreement is pretty damaging because it says that this is. But is this his address? Because remember in that case, if you guys watched my last stream, the court was like, we want bank records, we want the rental agreement, we want witnesses who can attest to it. So it seems like he's trying to get all this stuff. So he's given us now his Discover account from the statement period. Now the statement period starts from August 1st and it ends a day after the service to his mom's house. So it's been blacked out. Obviously, it's been redacted. And this is the address. So he has now a bank statement that he's getting bank statements from Discover to the new address before he was served. So showing that this was his primary address. Look, my banking statements are going to this new address. And he gives more than one. Here's another one. This is going to my new address. And this is the next month, I think. This is in November. So so he's showing, hey, I'm living at this other place. Here's some banking, and here's the address there. Then he shows this tax document. I think it's a 1099. Yeah, 1099 form. Again, the new address. So even his tax documents are going to this new address. And then he gives affidavit of residence. And this is from Susan Curtis, date February 10th, 2020, to whom it may concern. I, Susan Curtis, formally acknowledge Kyle Curtis as living at the street address, and this is the new street, 2543, since July 16th, 2019. So this is Mama, the person who supposedly signed for the document. She's attesting that, hey, he moved here, and that's where he's at now. He's not living here. He's living at this address, and she swears under penalty of perjury. Let me just check back on the chat because I've been monologuing. I've probably been missing some of these super chats been coming in. All right, yes, I missed a couple of you guys. Sorry, I've not been attentive to the chat, but I've been looking at this. All right, so Navy, I got you. Make sure. Let me see. I'm late. Boom. All right, Navy, that's in there. Let's go to the next one. Where you at? This super chat thing is tough. All right, here we go. Next super chat from Wholesome Buddy. Ultimately, I don't care about the case between these scumbags, but it is interesting to go over all the twists and turns. Yes. Who's your buddy? You're right. It is insane. Go ahead.
I was looking for that line too, and Raphael's pointing out because I can't find it. Last known address in NC laws for making counterclaims. And I was looking for that. I just said, fuck it, did Control F, trying to find what was quoted to me, and I don't find it. I find instances of words, but not in that sequence. So I think somebody was reading into the law that wasn't there.
Yeah, maybe give us a string side of some law. We'll copy and paste and check it out. I'm definitely interested. So please, yeah.
I'm looking just for the word known. So if the party's post office address is known or can with reasonable diligence be ascertained, there should be mailed to the party at or immediately prior to the first publication of a copy of the notice of service of process by publication. The mailing may be omitted. The post office address cannot be ascertained with reasonable diligence, and it goes into the different ways to I guess publicize.
Oh, because what happens is you can serve someone in a newspaper if you can't find them. Like if you do due diligence and they're looking for the person, it's like, yo, I can't find the person's address. I hired an investigator, no one can find this person. Then they'll but you have to request that generally. Again, I'm not sure how it's in California, in North Carolina, but generally you'd have to request for the court. Well, can I just put in some publication, newspaper, something like that, and then sometimes the court will allow you to serve the person that way.
Yeah, Raphael Block saying Rule 5 is for counterclaims. So I don't think we're in the right sections of North Carolina law.
Listen, it's Rule 4. We all know it's Rule 4. We all been screaming Rule 4. So maybe it's just something else. Super chat from Mo. What's going on? Love you, bro. Nate is a real lawyer. I've asked several attorneys I know personally about the law in perpetuity, and all cited and are exactly the same property statutes as Nate. Exact same property statutes as Nate. Wow. So in other words, yeah, again, every lawyer that I talk to says the same thing. They say, it's insane to say you can serve someone at someone else's address. That just doesn't make any sense, especially because the whole purpose of service is letting the person know that they're being sued. I can't, if you're going to send service letters to Dragnet's house for me, that makes no sense. It just doesn't make sense, especially with what you're trying to accomplish. You know what I mean?
Yeah, I mean, just outside of like this people's weird interpretation of the law, you're talking about inhibiting, potentially, I should say, jeopardizing somebody's due process.
Yes.
You're not directly giving that person access to their means of defending themselves at the very beginning of a legal proceeding. How is that in any way, shape, or form like fair according to the law? Not according to my opinion, or anybody else's opinion, the law. And I think, again, it comes back to people are trying to find ways to interpret law through their personal biases and not how the law is interpreted by legal professionals who practice in the state or the area that they're in.
I think it's yes. No, I think it's 100% true, and I think this it's not, to me, this just doesn't seem as simple as it's just being made out to seem, because especially and this just maybe my own personal issue with Steve is that usually if someone says my attorney tells me this and that person is licensed there, then I'm going to be like, all right, I believe that, it makes sense. But Steve is, he's so twisting it all the time that I just can't trust the fact that he's saying, if his attorney's saying this and this gets thrown out, then he's just made the attorney look even worse, So again, I would generally trust when someone says my attorney says that I don't have anything to worry about, but this is Steve we're talking about. So let me do this $5 super chat from Danger Man 5. Will it count against Kyle that his first appearance to the court was not that he was not notified? I think it does. It could. Because the issue here would be if someone has a court order that they have to respond to in a certain amount of time, or there may be consequences. You may want to respond to the court order and then notice that, hey, why am I responding to this court order? Oh, guess what? Because they sent the documents to the wrong place. If I never got the original documents, then I can say, well, yeah, I responded to court order because, their lawyer was harassing me, sending me letters every day. You owe us this document immediately, this. So I, and throwing a court order at me, then yeah, I'm going to respond to it. And then when I see what's going on, then I'm able to, but there could be some issues. So that's, again, I don't know the procedures in North Carolina, but I think if this service was done the way that Kyle is saying it was done, I think in the interest of justice, you can't let something like this stand, right? Because he did get a court order that he can, it's like the worst kind of catch-22. I got to comply with a court order, but I wasn't served properly. So, you know what I mean? It just is a hell of a situation to be in.
But the judge is going to be like, okay, well, you want me to bite on this and to get this out of here with prejudice, but you were sandbagging earlier, but now all of a sudden you don't throw this Hail Mary. So I would, like, if I had to put in my personal bias and what I'm going to speculate, that would probably hurt him if I'm the judge. Like, okay, now you want to do something. Now all of a sudden we could have saved all this time, but now late in the game, we're in the ninth inning, and now you want to try and hit a home run. All right, buddy. Okay.
but the thing is that this is not an infrequent thing that happens with default judgments, you know, a lot of them just go right down to the person just wasn't served properly. You know, you serve the person's old address or something like that. It happens here all the time. So it's not like this is some crazy thing that happens. It just, you know, I think in this case it's crazy because, you know, the whole characters behind it. But generally, you know, default judgments get thrown out all the time because, you know, people just don't get served properly. A lot of times it's the credit bureaus too. The credit bureaus, like, you know, you get an old credit card, people don't pay it, then they'll sue you, then you'll get a judgment, and people usually get their wages garnished, and they have to say, oh, why's my wages being garnished? Oh, some credit cards you had 3 years ago sued you, and that they got a judgment. Okay, now we got to find out what happened. So I think, hold on, this guy, somebody's saying something about, oh, you know what, let me go back on with the document. So let's move. Oh, I got super chats. What am I talking about? I'm going to the document that I got super chats. This counts. Yes, it did. I had another super chat I wanted to. Did I? That's $5 from Danger Man. Thank you, Danger Man.
So the issue with Polybird is that the part that you are reading on section 5 is for counterclaims. That's not for process serving. So there's a section for process, and there's different other subsections. You can't extrapolate from one section about counterclaims and say, well, that applies over here for process. That's not how the law works.
Yeah, that would be a little bit. I gotta go read that. But before I give you a firm answer, let me read it and say, because, you know, you could be making some interesting point, but I just don't know, because I'm, again,
let me link it
law. But yeah, because I wouldn't even be able to even read it now, and plus I would want to look at some cases about it to see how the courts have kind of settled that issue. But okay, so let's go back to the document. You see Susan Curtis's signature here on the document. Quick $5 super chat from Who's Your Buddy? It's the summons and the court order were sent to the same address. Could the judge conclude that he was served properly since he represented to the court? Well, again, proper service is different than being served, and we shouldn't conflate the two. For instance, if the court order went to the same address and he got it, that still doesn't mean that he was properly served, because let's say, for instance, if that was somebody else's address, let's say if it was totally the wrong address, let's say if it was a stranger's address and he got it, well, that still wouldn't create service, because it's about being served properly. It's not about being served at all. So, but again, maybe this may be a point that a contention in North Carolina, but I know here, if your service was incorrect, then even if you knew about it, it just doesn't matter. Or even if you knew about some other things, it just doesn't matter. Were you served properly and lawfully under the statute? Let me go back to reading the document. So now, just so because I know we got this super chat moving off topic a little bit. First, so we understand. So we have bank statements now, rental agreement, and we have his mom signing an affidavit saying that he hasn't lived at her address. He lived at this new address since July. And remember, Steve served that old address a month and a half later. So this is the evidence Kyle has been putting out. So I think right now we have a lot going on right now. You know, this is kind of crazy.
So
go ahead.
Potentially, Kyle can get away scot-free without having to pay McRae anything. Potentially.
Yeah, potentially, but it's potentially, or there could just be a trial, you know, and that'll be interesting if there's a trial, because he's
trying to get Steve to actually show up in court, and so that's when the trial would happen, I presume.
Yeah, I would suspect there would be depositions and all this other stuff. It would be a mess, but you know, now you're talking about really putting some money into a lawsuit to kind of litigate this. So you know, it wouldn't be easy. You're now talking about depositions. Now you're talking about getting Steve on record, and you know, Steve's, you know, loose lips with the you know, I told him to hold the money, but I did tell him to hold the money, and all the statements that he's making. It's not going to be an easy case to win for either side. I don't think it will be. Where does the responsibility lie on getting? Oh, this is from Navy Text. Where does the responsibility lie on providing the correct address? Well, the thing is that the responsibility lies generally with the plaintiff. It is the plaintiff's responsibility to find the defendant. It is the plaintiff's responsibility to serve. That's why you have process servers. That's why you have private investigators. You pay them to go find the person and serve them correctly. The plaintiff. It is the plaintiff's responsibility. I hope that cleared that up.
So I might have to head out here in a second. I want to see if Hogtie Champ wanted my spot because I know he has a fascination with the law.
Well, we only got like one more page, so it's
okay.
almost
Yeah,
done.
I'll stick around there.
All right, so we have the last thing we have is the last it's the last page. We have an affidavit of residence for Benjamin Potts. So this is the landlord to whom it may concern. I, Benjamin Potts, formerly acknowledged Kyle Curtis as living at street address, blah, 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 North Carolina since July 12th. So again, that's the landlord. I swear under penalty of perjury, the facts of forth in the statement are true and accurate. So boom, him again. So, and that's it. That's all the evidence Kyle has. So if we just look at it one more time, let me shrink this a little bit so we can see it. So his evidence is Steve's transcript and video. Steve's video. We have the rental agreement that he didn't live there. We also have his bank statements with his new address. We have tax documents with his new address. And we have an affidavit from mom saying he lived at this new address and an affidavit from his landlord saying he lived at the new address. So what do you think this is sufficient, Drag? Do you think he has an argument?
I think there's a big issue with how he was served, and it seems from what I've seen, and what we've actually discussed about the case law in North Carolina is that they are pretty strict on how you were supposed to handle a case, and I think that was dicked up from the very beginning. I think that Steve's lawyer did him a disservice by not ensuring that was Kyle's actual address before they did their little victory speech and dance, and I think that may be in Kyle's favor. But as far as whether or not this thing gets thrown out with prejudice, I think that's a hell of a long shot, because I'll go on record saying that Steve needs to be compensated what he's owed from what he put into that show, however much that is. But I think that it's going to be a huge long shot to have it thrown out with prejudice. But that's my limited understanding of the law. Folks, I belong in a lab among other nerds. So my understanding of law is just as remedial as everyone else's here outside of Nate and a few others. So take that with a grain of salt.
Hey, what's up, Hawk? Let me just read the super chat real quick. Learning with Suits just wanted to support my favorite lawyer and biochemist. Very good stream, gentlemen. Have a great night.
I'm not a biochemist. I do biochemistry research. I'm not a biochemist.
Thank you for the super chat. I really appreciate it. So, Hogtie, you up in here, man. We're about to get out of here. What are your feelings on what you're saying? Do you think it's enough?
You got over 300 viewers. I just wanted to pop in and make sure my face gets seen, which it's not because the fucking super chat is in the way. I got to go like this.
There we go. Matter of fact, I'll put it back on screen because we finished with that part of it. So what's up, bro? So what do you have to say? What do you think? Do you think this is enough, or do you think we don't got it?
Oh, it's a hard call. Everybody say it. I mean, I think the uphill battle here is sort of convincing some people they have to kind of unlearn some things they assumed, even in this chat. And I think, people are listening and they learn as they listen. But I'm still hearing a lot of the, last known address, or, then what is somebody supposed to do? Like, if I want to sue you, Nate, and you leave your apartment and you go live in a cardboard box somewhere, well, that's not fair to me. That's not fair to me. You have to tell the court that you left your apartment, you live in a cardboard box, right? And that's just not how it works.
No,
right?
It's definitely not how it works. And I think most people know that. Most like they keep saying you got to register. Like, I've never registered my address with anybody. You know what I'm saying? That doesn't make any sense.
No, hold on.
Who'd you register your address with?
Let me try this. Quick quiz, super fast, man. No long answer. You can do easy 5 seconds, okay? I want to give you I'm a police officer. I want to give you a speeding ticket because of the way you're operating your vehicle, but I don't stop you. I want to give you the ticket. Which address can I mail that ticket to?
Whatever's on file at the DMV.
Driver's license, right? I want to sue you in your capacity. You own a vehicle and there's some sort of a problem that caused me harm. I want to sue you in your capacity as the registered owner of a vehicle. I send that letter where?
DMV.
Registered vehicle registration, right? Mm-hmm. Dragnet Silvis, Nate Broady, form a company, Two Tubby Bitches Moving Company, and I feel that you guys ripped me off. So I want to sue your corporation. Where do I send the lawsuit to?
To the place where the place where the company is
we would have somebody. on like and I know at least to register a business, you have to have a place where your certified mail is sent to.
Yeah, business address, or you can even do it through the Secretary of State. There's like business. You know what I would say? Don't confuse people with the business service, because business service and the process is a little different, though.
Because the next question is, I'm not suing somebody who. Oh, sorry, the other one. I slip and fall on your property. I want to sue you in your capacity as the owner of a piece of land. Where do I set that?
Well, it's in rem now. They just the property, the property. Yeah, you send it right to the property. That's it. There's no you don't got to look for anybody. It's the property right there.
It's a tort system. Then yeah, you do land titles off. Great. But what if I want to sue you, Nate Broady, personally, and you live in a cardboard box? How do I serve you if I know what I'm doing?
Personal service.
I walk up to your cardboard box and
hand me the document.
Exactly.
Yeah.
And that's too bad. A lot of these lawsuits, people think it's somehow not fair that Kyle left and didn't call Steve and say, hey, look, I'm really sorry things went bad. And I know you want to sue me, and I don't want to make things any more difficult for you. So here's my new address. You swing by, drop off the papers. People are upset because Kyle, it seems shifty. It seems shifty. But you know, is it not the case that sometimes people have trouble suing other people because the defendant is sketchy as fuck and just wandered away?
Let me tell you. I'll tell you a story. A true story about a cop I knew who was being sued. Hold on, let me do this. Cable Leasework hog tie. Where would G-Man register his tent? Thanks for the super chat, Cable. That's wrong, man. That's wrong. But all right, so true story. So when I first when I first got on, right? So we're at the academy. And so a friend of mine, like after we graduate the academy, we're walking a beat. And so he's like, yo, I got to be careful. So I'm like, what do you got to be careful for? He's like, yo, people, I can't have anybody send me documents because my wife is trying to serve me for child support. So I'm like, oh, she's trying to serve you for child support, but she didn't know where he lived, but she knew where he worked. So what happens is we had this policy at the job where no one took service for no one else. Like, you got to go find that person and give him service. So that's what we did. We were like, all right, so nobody took service. This guy ran. This guy did everything to avoid. I'm talking about every possible thing to avoid service. Everything. I'm talking about, like, after work, she would stand in front with the process server to point him out. That's the guy. And literally his ass is running down the street because, he wouldn't be served. Like, it literally got that crazy. So to say that people want to be served process is ludicrous. People try to avoid service because that's just what people do. And the law makes it very clear that if you want to serve someone, there is very specific rules and specific ways to do it so you can start process against them. And, it's not crazy to think that if I want to get money from you, I have to find you and I have to sue you correctly. And that's all this is about. That's all this is about. But again, there are a whole bunch of different items that I think that we could be overlooking. For instance, there could be a procedural issue with Kyle, answering the thing first. And it could be a procedural issue that doesn't allow him to bring this motion. This could be, there could be time barred for some reason. It could be a whole bunch of different issues. But if you just ask me, was Kyle served correctly based on the information we have now and based on the information that Kyle's just provided, it's going to be a no. For me, it's just going to be a no. What do you think, Drag?
Yeah, I think that it's interesting that when we're talking about this procedural issue, again, I can't keep going back to people's personal biases are being interjected here at every turn. If it wasn't Kyle and Steve and it was person A and person B, would you be saying that? Would you be saying, hey, is it incumbent upon the person who is trying to sue someone to find the person they're trying to sue? Yes. It's ridiculous to presume that someone is going to lay there and allow you to sue them when they know that could hurt them in some, obviously detrimental way. So having the due diligence, right, that you're supposed to have when going through these proceedings, when you're paying a lawyer, when that person signs off on this person has been served properly, you would presume that it's been done properly, but mistakes were made. And then after we looked up who the lawyer is, he's a new guy, right? He's going through the motions, he's learning. This is a learning process for him, and I'm sure. But I think that people really have to start separating their personal biases from this. And I have to beat that dead horse over and over and over and over again. I, for one, would love Steve to get whatever his compensation is, for the fucking channel so it can be done over with, because it's funny as hell to me, but it's getting old. But it does not allow people just to say, well, Kyle knew about it, therefore we can just circumvent fucking law because I don't fucking like him. That's literally what people are saying at this point. Like, and it's ridiculous. It's just absolutely ridiculous.
No, you're 100% right. But Hogtie, in Canada, can you serve someone's previous address from 20 years ago and that be good service? Or is that, well, let me read the super chat from Twitch Chicolin. Yes. Steve learned law at Nuke School. Thank you for the $10 super chat. Oh my God! But go ahead, Hogtie. So in Canada, because I know you're more familiar with it because you've done like some lawsuits and things of nature.
Well, we did have some discussion. I want to get into it now about the acquiescence thing. Is it what happens if somebody responds to a dispute, responds to a claim against them, and then later, after filing their dispute note, says, "Oh, well, actually, I wasn't served properly." That does create a wrinkle. But to answer your question, no, you can't just leave it at a last known address or give it to a family member, trusting that they're going to give it to them. That when the statute prescribes a limited set of means that are appropriate to do proper, the law would consider proper service, you have to follow one of those means. And I understand. I mean, I really like Drag's point. I mean, maybe Nate, you could comment on what happened. What if we did things differently? What if we did make the service process rules a little more loosey goosey? I like Drag's point about, let's step back for a moment. It's Steve, it's Kyle. Some people like the one guy, they like the other guy, they don't like both guys. Whatever, it doesn't matter. The issue is I think where it rubs people the wrong way is this sort of everyman sense of justice, right? We all watch Kyle knowing for months that he's being sued. He knew he was going to get sued. He knew when he was being sued. He's looking at all these documents. We watch him looking through all these documents and talking about it on air. And then all of a sudden now notice he didn't come out and say, well, I didn't know I was being sued. He said, no, I wasn't served properly. And I think a lot of people are thinking, well, how can he claim he didn't know he was being sued? He knew damn well he was being sued. And I think there's sort of an everyman, layman sort of sense of justice that this really, really rubs people the wrong way. Like Kyle, don't like Kyle, whatever. It's pretty douchey for a guy to be in a lawsuit this far through this many motions and applications and then now go, no, improper service. But let's play through the other side of things. What happens? What would the world be like, Nate, if we allowed plaintiffs to skywrite their civil complaints, or as we say here, the civil claim, and just say, well, look, I did the best to send it to the guy? What would the world be like then? How is that less fair to me as a citizen who might be sued?
Well, but here, number one, there's a constitutional right to due process, so you got to be notified. It's notice and opportunity to be heard. But the way it would happen is that you'll have all these people out here with default judgments because you can sue. This whole process is to protect people from frivolous lawsuits and from lawsuits that they just don't know. You know what I'm saying? That's what this process is. It's a protection for everyone, that if you want to start a lawsuit against this person, you have to go through these things and sue them correctly to start process. This is not just a protection just for Kyle. This is a protection for every citizen here to make sure that somebody can't just sue you, you don't know about it, and get this huge judgment and garnish your wages. It's a protection for the public. So that's what the problem. That's what this whole process is. And that's why it's so tedious. Let me get this $5 super chat real quick from Gabriel 9193. Gotta run. Really respect how you've covered this and other cases. Sometimes I'd love to hear your take on prosecutors quitting Roger Stone mess. Oh, thank you. I definitely will check that out. But thanks again for the super chat. I really appreciate it. We're about to end this up in 5 minutes. So any last thoughts before we end this up, gentlemen? I'll start with Drag first because Drag said he had to leave.
I love like this is one of the things I love about when people say skeptic community. This shows you that not too many people are good at actually being objective and being impartial. That's one thing that I love, is to kind of show that, the proverbial putting the dog's face in its own shit sort of thing. And it's not even that contentious of a point to say that there's a process, there's precedent, there are statutes, and then there's your interpretation of reality. Some of these things aren't jiving too well together. And it is very interesting to see people repeat verbatim erroneous and clearly demonstrably wrong statements in light of facts. And so it is interesting for me, just from that aspect, as a voyeur of this. And on another, just my personal issue here with Kyle being the greatest pro se individual here, and he is clutching his pearls and about to seek his fainting couch because of the travesty that has befallen the North Carolina court. That's the best thing about this.
It's always.
I started reading it in Kyle's voice too. I was like, "Okay, bro, calm down.
Yeah.
We got it." But that's it.
Any last words, Hawkeye?
Well, I'm almost echoing what Drag had said. Love Steve, don't love Steve, love Kyle, don't love Kyle, just whatever. These are interesting learning opportunities. There are a lot of people, as we've been discussing this, saying, well, if you really wanted to set up a business like they did, there's better ways to set it up and better ways to document it. If you decide the other person's an asshole and you want to get away from them, not be in business with them anymore, there's better, more civil ways to get around it. If you're going to sue somebody, this all could be done much better. But it provides a really, really neat learning opportunity for us. And this is where I'm going to echo Drag's point. It's really interesting to watch a bunch of people get together in one of these on-air things and start talking, well, here's what the law says. And they just start telling you. People from Canada are now experts in North Carolina law. Just this afternoon, I had somebody tug me by the elbow and get, hey, hold on a second, Hogtie. I think you had something kind of right, but this thing about the person being over 18, it turns out we've looked it up and it's a bit subtly different than that. And I went, how was it now? And I had to learn even more about it today. So now if I have to sue someone in North Carolina, I've learned something thanks to YouTube. But just people, calm yourselves down. Von Helton did 2 years of real estate law, and that's how he knows that if you help somebody do copyright infringement, you could go to jail. Everybody calm down, learn. There's lots of great people on YouTube to learn from. It's a fun adventure.
It is. It really is.
And last word here is two things. Number one, I do want to just address this thing real quick. Just because we are critical to the claims that are being made by Steve doesn't mean we're on Kyle's side. And people need to just understand that. I am not on either one of these guys' side. To be honest with you, it doesn't really care who actually wins this case or not. I do feel, though, and I'll just be blunt, that Steve should get paid something from this whole endeavor.
Yeah.
That would be fair. The show did make money, and he should see some of the proceeds. For whatever reason, no matter how you feel about the guy, that would be a fair option. But I think at the end of the day, this service issue may be a real issue, and we'll see. Maybe the judge. One thing that you won't hear from me is that I'm going to say Kyle's argument is bullshit or Steve's argument is bullshit. They have an argument, and the judge will be the one to decide. If the judge decide that Kyle has no real argument, then that's the judge's, and that's the decision. That's the law. That's it. If he feels that he does, then you have another problem. But I think at the end of the day, right now, we just have the information. If the information that I'm looking at is correct, and the information that Kyle provided is correct, then I think to say that his argument is ridiculous, I think is ridiculous in and of itself. Would you agree, Hawktie?
Absolutely. Now we do the three of us are doing a power ending. 1, 2, 3 for justice.
Yeah.
Oh fuck! You guys didn't read the private chat. I had this all planned out. Next time.
My name is Nate. For Hawktie Champ and Dragnot Silvis, who's over here, and for Nate Brody's lamp in the background here. You guys take care, and we are going to see you next time. That's right.
Justice.
See ya.
Justice.